FATA is no more. On 31st May 2018, the federally administered tribal areas of Pakistan were merged with the province of Khyber Pakhtunkhwa. Yet centuries of neglect do not simply disappear overnight, and the merger seems to be only the beginning of this journey. Today, we explore what these reforms do and the main challenges that lie ahead.
Mainstreaming FATA is no easy task. Its entire system of governance under the Frontier Crimes Regulation is vastly different from the rest of the country.
FATA was governed by the infamous Frontier Crimes Regulations, or the FCR, a colonial-era law through which the frontier tribes were indirectly governed by the British Raj, and later the government of Pakistan.
If a crime was committed in FATA, there was no police force to investigate it. Instead, a council of elders from amongst the tribes themselves would decide issues of fact based on their own rivaj or customs, and present their findings to the political agent for a decision.
The political agent was a civil servant with wide executive and judicial powers and could convict or punish anyone in FATA. The right to appeal such a decision was very limited, as neither of the high courts nor the Supreme Court of Pakistan had any jurisdiction over FATA. Article 247 of the Constitution empowered the President to directly issue regulations for the governance of FATA. The national and provincial assemblies had no jurisdiction over this region.
The 31st Constitutional Amendment has thankfully changed all of this, at least on paper. But the political, economic, legal and administrative mainstreaming of FATA remains a major challenge.
The FATA reforms were brought about by three legal changes. The overarching legal cover for the merger was provided by the 31st Constitutional Amendment, which removed all references to FATA in the Constitution and deleted Article 247. The jurisdiction of the Supreme Court of Pakistan and the Peshawar High Court were extended to FATA by an Act of Parliament. The FCR has been repealed, but to avoid a legal vacuum during this transition, interim governance regulations were put in place, which replicate large portions of the FCR with some cosmetic changes. Political agents, for example, will now be called deputy commissioners.
The interim regulations make some important changes to how FATA is governed, but many controversial elements of the FCR have been retained. For example, the third schedule of the interim regulations still allow a deputy commissioner to collectively fine groups of people, exile individuals from FATA, or limit their movement to specific areas within the region.
The plan all along was to gradually merge FATA with KP. The FATA Reforms Committee had suggested a 5-year transition period in which the FCR would be gradually phased out, and fast-track reforms could take place through presidential regulations under Article 247. However, I think that the political consensus was in favor of an immediate merger with no transition period. Perhaps this is why Article 247 was deleted with immediate effect. Article 247 provided the legal source under which presidential regulations could be issued. Now, since the legal source has been removed, one argument is that all the subordinate presidential regulations have also ceased to exist, especially since there is no savings clause in the amendment. Under this argument, the interim regulations themselves can be challenged for having no legal validity.
Before the merger, Article 247 of the Constitution used to bar the superior courts from exercising any jurisdiction in FATA. Thus, any presidential regulation could never be challenged, even if it was inconsistent with fundamental rights such as fair trial, arrest and detentions, or property rights.
The interim regulations are basically a watered-down version of the FCR. Many of its provisions, in my view, will not withstand scrutiny by the courts, and it is possible that large chunks of these regulations are struck down. The KP Provincial Assembly needs to be aware of this fact because it might plunge FATA into a legal vacuum.
With the superior judiciary now having jurisdiction, the people of FATA will have a very strong tool to enforce their human rights, not only in terms of the draconian legislation that's been passed, but also the administrative actions of government officials. These are all subject to judicial scrutiny now, and frankly, it's quite revolutionary. One thing in particular is to see how the judiciary deals with the ongoing military operations in FATA, especially issues such as detentions or deaths that take place during these operations.
Policing the former tribal areas is probably one of the most immediate challenges. The local police in FATA are known as khasadars, whose job is restricted to protecting the roads and government installations. The levies, on the other hand, are a security force. Both of these forces have absolutely no experience in investigations, which is a core function of a police force. Until this capacity is not developed, you cannot have a functioning criminal justice system.
The Khasadars are an 18,000-man strong force, but most lack even basic education, are often overage and have no formal training as such. But abolishing the Khasadars can cause major resentment in the region, since all the tribes have a predetermined quota of employment in this force. The Reforms Committee had recommended that policing should be taken over by the levies. The KP police now faces this great challenge of converting a paramilitary force into an all-round police force with investigative capabilities and one that is well versed in our complicated criminal procedure.
The legislative responsibility for mainstreaming FATA now lies with the KP Assembly. Fast-track legislative reform is required on multiple fronts, from socio-economic development to land settlement to civil and criminal justice reform and policing. The provincial government is going to require a lot of support from the federal government to take on this gigantic task.